10 judges coming from the farthest land. ತುಂಬ ದೂರದಿಂದ 10 ಜನ ನ್ಯಾಯಾಧೀಶರು ಬಂದಿದ್ದಾರೆ. If they were to be 9, I would have reminded them of Justice Oliver Wendell Holmes' comment, 9 scorpions in a bottle. But that is not applicable for 2 apparent reasons. They happen to be judges of the other courts and the number is also different, though to that extent they are safe. Our chief architect of the Constitution, Dr. Ambedkar, his mindset was formed in your state, in America. Many of the writings which he produced, scholarly writings by the standards of those days, were done on American soil. And part 3 of our Constitution, we have borrowed from your Constitution, Bill of Rights, the first 10 amendments. Then John Marshall's famous statement, the judicial review of legislative actions. Perhaps if John Marshall were to be alive today, he would have sued Madam for telling that judicial review was there even before 1803. That is true. There was judicial review even before that. But there was judicial review of legislative action in England during Edward Coke's time. So that will date back to much earlier to your view. But our judicial review of constitutional legislations is comparatively enormous compared to your power of judicial review. That is, especially from the days of I.C. Golaknath versus State of Punjab, then Union Maharaja Raja the Raja Madhavrao Scindia versus Union of India, R.C. Cooper versus Union of India, 1973 Keshwananda Bharati, Minerva Mills, then Sanjeeva Coke. Then like this, the power has been enormously, it is said, we have usurped the power of adjudging the legislative instruments. But we have one great thing. What happened in your English, in your American judicial history at the black spot at Dred Scott decision in 1857, that happened in our country in 1975, popularly known as habeas corpus case, ADM Jabalpur versus Shivkant Shukla. What the judges, majority judges did in Dred Scott, majority of judges of our Supreme Court did in ADM Jabalpur versus Shivkant Shukla. But there is one difference. You also rectified. You marched much forward from the days of Dred Scott to the days of liberty of citizens. You started treating the black people, the African people as citizens, whom you had treated, the America had treated only as property. But in our state of India, we have been treating even animals as having the rights which your legislation has not found out. Your whole judicial system, legal system, administrative system, governmental system that has been bedrocked on the principle and which focuses, it is anthropocentric. Ours is not anthropocentric, ours is all creature, non-creature centric. That is the great difference between your country and our country. Some of the high courts in our country have declared rivers as the living persons capable of rights which only the natural persons or legal persons in your American system are recognized. But we recognize trees, the forests, the woods, the rivers, the lakes as being the living persons, and we worship them. Vanadevata. This is one great difference. Then in your country, of course, our makers of the Constitution visited, like Justice our B.N. Rao, Benegal Narsinga Rao, Dr. Ambedkar ji sent Dr. Benegal Narsinga Rao to your state, to America, who had discussion with Felix Frankfurter, and much of the discussion resulted into enactment of some provisions in our Constitution. But we differed also. B.N. Rao did not agree that the residuary legislative power should rest with the states. Unlike in your country, the residuary legislative power rests with the states and not with the federal unit. In India, the residuary power lies with the center. That is one difference. The second difference is we have marched forward. We have taken the constitution to the different level, in the sense the power to appoint the judges is now largely with the judiciary. The power to appoint judges in US Supreme Court is with the president, is with the executive. But now it is so independent. Of course, I am not saying that you are not independent judges. You have been independent judges, although efforts were made in 1941 when the president, particular president, I will not name him, he said he would pack the judges of his ideology, government's ideology, in the US Supreme Court. Of course, in 1973-74, it happened with the statement of Law Minister Mohan Kumar Mangalam. We said committed judiciary. Your people resisted what one president wanted to do. Of course, some judges said what that president wanted to do, almost all presidents also wanted to do. This is what the same book that John Marshall's Unprecedented says. Then we people, we did not stop. We fought against the government of the day when it had imposed emergency. Our judiciary stood up, and ours, this High Court, where we have the privilege of treating you, privilege of honoring you. This court happened to be one of the 9 high courts in the country which had issued writ of habeas corpus, and we were carrying the might of the then central government. You have also held right to travel abroad is one of the basic rights. We held that in 1964. This court held it 5 years earlier to your court holding it. In 1964, we are just saying Maneka Gandhi, etc. What Maneka Gandhi? Maneka Gandhi came in 78, 79. In 1964, the year when I was born, this court has said right to travel abroad is fundamental right relatable to Article 21 literature. This is the difference. There is one difference. Having said this, I should also share your courts for some time cottoned with equal but separate. Our court never cottoned with that idea at all. Equal means equal. We are all equal regardless of caste system, Varna system, whichever system. We treat everybody, and these things which differentiate people from other people do not exist in our system at all. And ours is a vibrant democracy, as vibrant, if not more vibrant than your democracy, because New York Times wrote in 1989, the millions of people going to the voting for polling stations and having small pencil, chalk piece or a pencil in their hands, making a small mark on the ballot paper which would decide the future of this country. This is the greatness of our Indian judiciary and Indian system also. When in some countries you have seen, like history in Ghana, where the judges were hearing one constitutional validity of a legislation, a government policy was being challenged in Ghana, and when the matter was going on, Ghana Chief Justice expressed, perhaps this policy appears to be constitutionally defective. And next day, the government issued a notification saying that the Chief Justice is not well and therefore he is not holding sittings. Very next day, another notification came to be issued saying the Chief Justice is dead. Then one more notification came to be issued saying the Chief Justice died in natural circumstances. This never happened in our land and would never happen, I assure you, it will never happen in our land also. At no point in time that we will allow it to happen. We have many scholars whom we refer in our constitutional jurisprudence. We refer to Justice Black. We refer to Justice Oliver Wendell Holmes. We refer to Justice Felix Frankfurter. We have taken his advice also while framing the Constitution on whenever B.N. Rao went there. For hours together discussion was held. And we refer to the many recent judges of US Supreme Court also. But in Charanjit Lal Sahu versus Union of India, for the first time we said, though we are guided by the wisdom coming from other countries, we should develop our indigenous jurisprudence because our problems are unique to our people. But we are indebted to America, as America, rightly said by one of the judges, is indebted to India also. Though our people may not be knowing the provisions of the Constitution, the provisions of the statutes, unlike your people, where legal literacy level is very, very high, but the constitutional values of our people lie, as the Dicey used to say, in the hearts of our people. People will not be knowing the provisions of the Constitution. If you ask them what Article 1 says, what Article 11 says, what Article 12 says, 226, 227, 228, 32, they will not be knowing. But when there is injury, they understand that sense of justice is breached. And they come to court. They choose the lawyers and we entertain then petition. There is one more difference between our judicial system and yours. Your judicial system is very strict when it comes to pleadings. We are not that strict. Though we expect there should be formal pleadings, and we have the greatness of treating 15 paise postcard as the petition and granting justice to the millions of people. We treated one single article of Arun Shauri published perhaps in India Today as the PIL, and we released 51,000 people who were languishing the jails even after the maximum term of punishment was over. Rudolph Shah versus so-and-so, series of such judgments. Such judgments, I am sorry that I am not making any adverse comment. I am acknowledging the much water has flowed from river Mississippi to Sipra, Ganga, Kaveri. We should go together, and wherever justice is threatened, be it on the other part of the globe or in Bangalore or in Buffalo, it is a threat to justice everywhere. Last, I have to say, because of the constraint of the time, we have one grievance. Why Felix Frankfurter did not advise B.N. Rao to have a constitutional tradition, which we have, when if there is rains, when the court is sitting in more than 7 states, the court will raise to have the drinks. No sitting in the afternoon. But that tradition we did not have. That is the only tradition. Thank you. Thank you so much.
Now I request Honorable Mr. Justice Sarah L. Elias, Judge, U.S. District Court, Northern District of Illinois.
Again, I want to echo my colleagues in thanking you for your hospitality and your generosity, your warmth and your kindness. Coming to India has been an amazing experience for me. This is my first time, and I hope not my last, because this is a beautiful, wonderful country, and I have learned so much. So in talking about the independence of the judiciary and democracy, one of the things that I get to do as a district court judge is swear in new citizens. And in the naturalization ceremony, I often talk about democracy and what that means. When I was a student, I studied art history and lived in Rome for a little bit. And one of the things that I liked to do was go to the Vatican Museum. And in the Vatican Museum, there were hallways filled with these magnificent, beautiful tapestries. And as I've traveled around India, I have seen similar, beautiful, beautiful tapestries. This artwork that on the front presents a cohesive picture that is breathtaking. over and flip them over, often you can't tell what the image is on the front. That on the back it is chaos. And you see knots, and you see all these individual threads that are woven through. And that these tapestries often are very delicate and fragile. And that's what we need to understand about democracy, is that it is delicate, it is fragile, we must take care of it, that it is chaos at times, but that when it works, it creates something that is magical and beautiful and aspirational for the world. I see that in India, I see that in the United States. And one of the things that makes our tapestry, this democracy, so strong is an independent judiciary. But how we keep an independent judiciary is that the judges must comport themselves with the highest sense of ethics so that they do not erode public confidence in their decisions. In decisions that, as Judge Staten says, may go against the will of the people at times, but that say what the law is and what the law should be. So I am thrilled to be here in India, to go through this exchange of ideas, to go back with more knowledge than I came. So thank you to the wonderful people of India.
It's wonderful to be here. I am, like so many of you, of course, a descendant of the colonial experience. I'm Puerto Rican. My family came from Puerto Rico, a colony of the United States, and so I very much appreciate the struggle for freedom, the interest and commitment to creating your own courts, your own system of law, but that is based in your traditions and your history. So I bow to you in the work that you have done here. Thank you for that. I've learned a great deal from you. So I come from New York State, and so much like India and so much like the rest of the United States, we are a multilingual, multicultural state. And I very much enjoyed learning so much out of every place that we've gone to, that there are similarities, through line through all of them, and yet specific customs, specific differences, like in New York. So it's wonderful to see how all of that harmonizes to have an Indian spirit. But I come to talk to you in the brief moments that I have about justice. I was just talking about that at the school we visited this morning. Justice to me is the one common theme that connects everyone in the legal profession. Judge, lawyer, advocate, and the litigants eventually. It is about the pursuit of justice, however we may define that in our cultural, historical experience. But at the end of the day, it is about what is fair and right, and about equality and equity. So, to me, justice is really about procedural justice, all those rules of process that you're bound by, judges are bound by, that ensures some continuity and some sense of knowing how things will proceed, but also substantive justice, right? That things that go on in that courtroom and outside that courtroom are always with the goal of doing what is fair based on the facts and the law as applied to that case. That we do not let the voiceless go unheard in whatever case comes before you. So again, thank you so much for this experience.
Origin.
Good afternoon, and thank you so very, very much for having us. You're all trial lawyers and you need to go to work, and we're so impressed that all of you are here. I mean, there's a spillover out to the back to come hear us, and when we know you have so much work to do, we've looked at your dockets, we've looked at the work that you have to do on behalf of the public, and so it is beyond overwhelming for us to see how many people have come to talk with us today. It needs to be a dialogue. I hope this will continue down the road. I'd like to just tell you a few things that I think might be helpful and a little different. I am a member of the U.S. District Court, which is the federal court system, and as has been mentioned, it's a lifetime appointment. And I would never have dreamed I would have that opportunity. So I'm looking around the room, and I have to honestly say, I don't see so many women. I'd like to see more women, and let me tell you why that's important. When I was nominated for the federal bench in 1994, and we began the process, and we were nominated by President Bill Clinton, it was the largest number of women and minorities nominated in our group. And politics changed. You know how that happens. It changed, and we were held up, many of us, for four years to be confirmed. So over my lifetime on the bench, from 1998 until now, I have watched the courts go from a court that looked like a monolith with very few women. I was only the second woman on my court. Of 6 judges, I was number 23, second woman. And to now, where I just have to tell you, I can't tell you how proud I am of the delegation that has come together and come to represent the judiciary, state and federal, in our country. This is not the delegation you would have seen in 1998. Every person here is a cutting edge, incredibly well respected, intellectually curious, totally committed, legal scholar, but more importantly, a person with a heart. They all have compassion, a heart, and they understand the integrity. The only thing we have in our job is integrity, and they all have it. So if you look at in this country of yours versus ours, the numbers are 9 Supreme Court justices. That's 9. Of the appellate court, there are 179 appellate judges in 13 circuits. There are 677 district court judges, of which I'm proud to be a trial judge and be part of that, and 94 districts. That's our federal judiciary, and there are other positions, but that's generally our federal judiciary. So what I would tell you is, what's so important is what is being done and what we've witnessed. You're investing in the education of your young people, and you're growing the talent, the lawyers, the technology, the infrastructure to problem solve and make a difference in India. And we have witnessed it and seen it in so much color and context. You're ahead of us. Push us, just as we ask lawyers to come into the courtroom and make us do our job and make us hear your arguments and make us do better work, just as we need to do that on behalf of every country. We need to better educate our kids. We need to bring diversity to the bench, and we need to make sure that it is representative for all. And at the end of the day, justice is about fairness, and it's about equal opportunity, and that this world becomes something more together than the haves and the have-nots. We have to come together and save this planet, this world, this justice system, so that every one of our children, grandchildren, and the stewards that we are for the next generation have opportunities. And you're doing it here, and it's been something to behold. And as tired as we are, it is inspirational. Thank you.
ADRESS, Judge Supreme Court of Hawaii.
Aloha and namaste. I serve on the Hawaii Supreme Court and absolutely love it. We are a state of 1.4 million people, 1,000 times less than your folks' population in this great country. But we have a close tie and a spirit. In Hawaii, we revere nature, just like you folks. We respect the human dignity and the liberty of everybody, from the top of the socioeconomic scale to the bottom. And we have a tradition of giving lovely flower leis as a greeting. So thank you very much for your hospitality. You know, as far as the independence of the judiciary, you folks are absolutely vital to protecting the independent judiciary, to keeping the rule of law. I was a trial lawyer for 25 years before I became a judge. I was in court every day. And you know what? This is an honorable profession. And what we need to do with our profession is to not only represent our clients, but to ensure that the judiciary is independent. This is where we work. If this judiciary and any judiciary and any constitutional democracy is undermined by political forces, the rule of law is eroded. We have a noble profession. And judges cannot speak for ourselves. We write opinions, and that's it. We need the assistance and skills of you folks to come out and ensure the independence of the judiciary and to ensure that your citizenry is educated on what the judiciary is doing. So it is an absolutely critical role that you play in educating the public, ensuring an independent judiciary, and also ensuring a free press. A free press provides transparency to government. It provides openness. It casts a spotlight on everything that's done. An independent judiciary will not function without a free press, without an engaged citizenry, and without people like you. So thank you very much for having us here today.
Aloha and namaste. I am Sabrina McKenna from the Supreme Court of the state of Hawaii. We are the youngest of the 50 states, and I'm originally from Japan, and I believe a lot of our culture came from India, through Asia, and through the Pacific Ocean to Hawaii. We honor nature, we honor the spirit of people, and we respect each other. And we are the most diverse state in the United States. We are the only state that is not majority white people. We have so many different cultures. 25% of our population speaks a language other than English at home, and we have many religions and cultures in Hawaii, including people from India. So please come visit us. So today I am going to focus on the topic of the American Constitution. Our constitutions, as compared to the British Constitution, are written. So I am going to say that what's important to understand that in the United States, we don't just have one constitution. Each of the 50 states has its own constitution, and each of those 50 states have individual rights within the Constitution, usually in Article 1 of the state constitutions. Under our federal system, we are free to interpret our state constitutions to give greater rights than provided under the federal Constitution. In Hawaii, we have always taken that right and obligation very seriously. Our state constitutions also have positive rights that do not exist in the federal Constitution, such as the right to a clean and healthful environment in our Constitution, which Justice Edens wrote an opinion judgment earlier this year that Justice Wilson and I joined, that recognizes that the right to a clean and healthful environment includes the right to a life-sustaining climate system. So what I want you to understand is that the Constitution is not just the federal Constitution. Our Constitution includes the state constitutions. And who has heard of Marbury versus Madison? The doctrine of judicial review, United States Supreme Court, 1803. We are taught in law school, I was taught that is when judicial review started. No, that is not true. Each of the states had judicial review. The 13 original colonies that became states, many of them already exercised judicial review, struck down statutes, state laws based on unconstitutionality under state constitutions. So by the time Marbury versus Madison came out in 1803, judicial review was already well established through the state Supreme Courts. And finally, I just want to note that Jenny Rivera, each state has its own court system. Almost all states, our highest apex court, which is free and the final decision maker of all issues of state constitution and state law, is called the Supreme Court. But in New York, for some reason, calls their Supreme Court the Court of Appeals. So if you watch Law and Order and you see Supreme Court and you see the trial division, that's what New York calls their trial courts. Their district court is the Supreme Court. Court of Appeals is the highest court in New York, and she is one of the 7 justices of that state. Thank you so much for having us.
Aloha. And that is the word that kind of summarizes the spirit of Hawaii But whenever we say it, Justice Edens, myself, Dean Nelson, Justice McKenna, we think namaste, which is this beautiful heart of India, which we have had a chance to experience before. We've done some travels. This travel, I won't explain it to you because it'll tear your mind and you'll feel sorry for us because Justice Kumar has, Dean Kumar has us working so hard. But we have been to the bar of New Delhi. We've been to the bar of Mumbai. We've been to the bar of Chennai. But nowhere have we been treated like we have been treated in the bar of BENGALURU. Wow. So I'm going to ask Raj, is it okay if I stay here? This is such a cool place. No, really, to see this room filled with the freedom fighters of India, it gives me chicken skin. This is what we think of for when we come from Hawaii. You know, our democracy is under siege, and it's under siege by our court. The United States Supreme Court, right? They took away a fundamental right, the constitutional right of a woman to decide about her body. That was powerful. It's a message. And how many judges are going to be able to proceed in that kind of an environment? Well, it depends on whether we have freedom fighters in the United States. We've been with some freedom fighters on another issue here. And those of you in the room, I know that I mentioned this word climate change too, will start having all sorts of thoughts in your mind. One of the thoughts we have is that we just had 100 people burned to death in Maui. I know what's happening with respect to, of course, sea level rise with Bangladesh. That means over 100 million people are going to be heading towards India. Who are the freedom fighters I'm referring to? We've been to the law schools. The professors, the students, they're not giving up. In Jindal, there's a group called the Final Stand. They have gathered together to say they're not going to let that happen to Mother India. And they're working hard to make sure there's a climate protection plan and make sure that India helps lead the way in reducing greenhouse gas emissions sufficiently to protect the planet. So, yes, in Hawaii, you've made a big difference to us. When 2 of your Supreme Court Chief Justices came to visit, inspired us. The jurisprudence you've heard about that Justice Edens has written brilliantly about, well, he'll tell you, it was derived in part because of our experience with you, who, you know, comes from this idea of being a freedom fighter. So, Mr. President, thank you so much for your reference to the fact that Gandhi inspired Martin Luther King. It's very true. You always inspire us as judges, and thank you for sitting here. And it's not that warm. It's not as warm as it was in Mumbai, but I'm sure it's a little bit uncomfortable. But I'm so proud to wear my Bengaluru Bar Association outfit.
It would be some homecoming which Justice DIXIT just now mentioned. I have been a member of this association for more than 60 years. It is only in fitness of things I decline to be honored, because I am a member of this association. Why should I honor myself? There was no need for it. Vivek Reddy has a special advantage so far as this bar association is concerned. He has inherited a right from his father. His father had been the president of this bar association for more than 14 years. In fact, I suggested to him, you become a lifetime president. That is how it used to be in those days. Let me assure you, I do not want to engage in any debate whether Indian Constitution is better than American Constitution or American Constitution is superior to our Constitution. One thing, all of us, all the constitutions in the world where there is democracy prevailing, they are inspired by one statement made by Thomas Jefferson in the Declaration of Independence he made when they became free from the colonialism. He stated that man being born as a human being has an inherent and inalienable right to life, liberty, equality, and human dignity. In order to save this, protect these rights there must be a competent judiciary. Every country has this. It is America, it is Canada, it is England, it is UK or France, Germany. Every democratic country has this kind of system. Maybe there may be here and there in matters of detail, there can be variations. We may accept one detail or the other detail, but in substance, these rights ought to be protected. Depending upon the history of the country and the context in which the problems arise, we try to solve the various issues. It is not as though we have ignored a few rights or appear to highlight certain other rights. All of us have got certain basic rights, or everybody has got it. It is those who are very well versed with human discourse, particularly Professor Rajkumar, who was well aware of it, he knows that this is what Thomas Jefferson said, is the substance of everything, every right. Constitutions do not mention rights. Constitutions merely set out the values thereof. The rights are inherent and inalienable in a human being. If that is so, what does the Constitution do? Constitution puts an embargo upon the states not to interfere with those rights. In the event those rights are interfered with, courts do step in and save those rights. That is what is happening all over the world. In fact, after the Constitution was adopted, Dr. Ambedkar, in his last speech on the last day, stated that from tomorrow, every one of you, each one of the citizens of this country will have an equal right. Politically, we are all equal, but socially and economically, we cannot claim to be equal. This problem has arisen not only in our country, even in America. That is why they adopted the system of affirmative resolution of matter. In fact, we adopted reservation, they use the expression affirmative action. This is how the variations occur. Moreover, the problems that arise, for example, the independence of judiciary is talked of, whether a judge is appointed during the presidency of a Republican party or Democratic party. They may come into the office. Once they come into the office, not necessarily they adopt everything that the Republican Party or the Democratic Party has adopted. This we have experienced in more than one case. Indeed, even in case where there is a political issue involved, Gore versus Bush, it was pointed out that seven judges wrote one judgment, 2 judges differed from it. 7 judges upheld the election, declaration of the election by the Florida court, so far as Bush is concerned. But 2 judges who concurred with them disagreed with the reasoning adopted. That way, a dissent in a consent judgment. This kind of analysis, if you go into it, it will lead nowhere. See, that kind of analysis, we cannot engage in a seminar of this nature, where large gathering is there, you are waiting to wind up the proceedings as quickly as possible to go back to courts. At any rate, the question is one of right to property, all right. In fact, in India, we dropped the right to property as a fundamental right because it is an acquired right. Therefore, it is not necessary to have it. But sufficient protection is provided in so far as unnecessary interference is concerned, and a special provision, and such provisions are there all over the world. Even in American Constitution has got ever so many variations from our Constitution. We too adopt or get enlightened by the great thinking of the judges of America. We adopt some of those ideas, and we also provide ideas for them to adopt. The problems like reproductive rights, in regard to that, there have been several decisions both in India and in America. there have been differences, there have been resolutions, agreement. This kind of exercise goes on all over. Therefore, we need not claim that our constitution is superior or their constitution is inferior. All constitutions depend upon its own history and context and the need. So far as independence of judiciary is concerned, I do not know how you put it. Is it because the Congress party appointed, during Congress party's rule, when somebody was appointed, they would support the issues relating to Congress party, or some other party that came into power? It doesn't happen like that. In fact, independence, in my view, depends upon the judge himself. Judge must be independent of himself. He must rise above his own prejudices and pride. He takes the oath of deciding matters without fear or favor, affection or ill will. If that is so, if he does stand by it, he'll be totally become independent. That way, it more depends upon the particular judges who deal with the matter, their values, their outlook into the matter, not necessarily the institution as such is independent or not independent. Depending upon the needs of the time, to what extent the executive must be involved in the appointment of judges, to what extent they should not, it all can be worked out. In the course of time, we can all adjust on that. That need not by itself bog down your own thinking. We can rise above that level and adjust our doing. Of course, very forceful speech was made by Justice DIXIT. In fact, he tried to impress upon us that his constitution is the most superior. But it is no doubt, there are very great values in it. Every constitution sets out the values in it. Therefore, we must take them in the context and the history of each one of these nations. That way, we can adjust, understand, and exchange ideas, and not only by merely meeting, even in the matter of writing. I wish all those judges who have come from states a very happy tour in India, and they can be exposed more to the system of administration of justice in our country. We are welcome again. Thank you very much.
American Constitution and Independence of Judiciary. And just to rejoin with one small rejoinder, if 12 judges on the bench would allow, both Indian and US. I think Justice Aiken was mentioning about women coming into the profession, and of late, we find that in the recent civil judge recruitment, there were more women, more than 50 women out of 70 who were appointed as judges. And this is a very wonderful development, and I'm sure in days to come, women will really bother the men and compete against us. Thank you very much.
Respected leaders on the race and of the race, respected senior councils and DSs. ಈ ಒಂದು ಸುಂದರ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಮುಖ್ಯ ಅತಿಥಿಗಳಾಗಿ ಆಗಮಿಸಿದಂಥ ಆಹಾರ ಸೆಕ್ರೆಟರಿ ಶ್ರೀ ಎಸ್ ರಾಜೇಂದ್ರ ಅವರು, ದಯಮಾಡಿ ಕ್ಷಮಿಸಿ, ಈ ಮಧ್ಯದಲ್ಲಿ ಯಾರು.
Perhaps the biggest contribution from the United States Constitution to us is the concept of due process of law, which, as DIXIT said, we did not incorporate. We used the word, the procedure established by law, by the Supreme Court of India. In Maneka Gandhi, ultimately we adopted the due process of law. Therefore, instead of asking the questions, I would say, thank you, American Constitution. And I want to know how far you have gone further in the concept of due process. Of course, the rule of law is our biggest achievement in Indian judicial segment. And the question of due process of law, which we adopted from your constitution, though as a procedure established by law, metamorphosed into the due process of law, I just want to know what further progress you have made in the American judicial system.
I understand and appreciate the interest in this question, which is a wonderful question about how much have we in the United States advanced with the very important principle of due process. And now things are happening that I guess would be considered to be unusual in our jurisprudence, in the sense that our due process for a long time was so important, and it included very important fundamental freedoms. You know, freedom to have effective assistance to counsel, freedom of speech, the right against self-incrimination. These things were incorporated as part of a due process clause. But the idea of actual process, how much procedure do you get before your rights are protected, has received a shock. I refer to it as shock because incremental protection of an important right, like a very personal right to determine whether a reproductive choice is going to be taken by a woman. My goodness, for 50 years, that was a fundamental right, and all of a sudden, it was taken away. So we have scholars addressing that now. It's a breathtaking change. It seems to me that you have a group of people who decided to make a public policy decision, I guess a bit like the executive or the legislature, and they just changed the law. Didn't have much notice. It was a shock to certainly at least, maybe half our population. So I'll just cite that as an example of how there's a lot of change taking place. And then there's an idea of due process. I should let these great judges who have addressed this issue specifically in their decisions, but we've had a decision in the area that's considered the most fundamental right now in some of our jurisprudence, which is the right to a healthy climate. It means that all other rights depend upon it if we can't have a healthy climate. And that's a struggle, but the jurisprudence behind it and the common sense is part of India's history. Your right to life, Article 21, is so expansive, rightfully so. So that can include the concept in a process, a substantive due process sense of giving the citizens the right to a life-sustaining climate. I have no doubt when that issue comes to the court, it's very likely to decide it. But that's different than what's happening in the United States, where the states are moving in that direction. Some brave federal judges are, but it's being worked out on behalf of, the young people in our country. And yours too. I mean, you have more young people, 440 million in any other country, so it's an even more important due process consideration for them. Sorry to go on for so long, but it's a great question, and I couldn't help spending some time on it. Thank you.
Louder.
And all my fellow advocates, my question is to the American dignitaries. Sir, Madam, in what way the jury system is contributing to independence in the American judiciary?
And that's a fantastic question, because that's the difference between the Indian system as I understand it and the American system. And I'm a federal trial judge, and so I do a lot of jury trials. And when I was a lawyer, I was very suspicious of the jury, because I thought to myself, I didn't understand how 12 people off the street would understand the law sufficiently to come to the right decision, and were they coming to it, to the process with sufficient seriousness about what was actually happening. As a judge, at the end of every trial, I go back and I speak to our jurors, and I give them a certificate of appreciation and a letter if they need to take it to their employer, and I let them ask me questions about the trial. I am astounded every time by how thoughtful their questions are, by how seriously they take the task before them, that they understand that they are undertaking a constitutional obligation every time that they sit as a juror. And how that relates to the independence of the judiciary is that I tell them, I am the judge of the law, that they are the judges of the facts. And so I tell them what the law is, but they decide what the facts are, and they apply those facts to the law and come to a decision. And I think that that gives confidence in our legal system, which is the foundation of our democracy. It's what holds it up. That people will understand that our jurors take their job seriously. That when they come to a verdict, they have looked at all the evidence. They have listened to all the facts. They then get the law in a written form, and they apply those instructions to the facts. And it is not a judge that is saying, this is what the verdict should be, because this is what I believe, this is what pointed me. But instead, people from our community who take their obligation under the Constitution so seriously. So I think that it bolsters the independence of the judiciary. Thank you.
That's a great question. The collective wisdom of 12 people who listen to evidence, apply that evidence, find facts, work with the law, and do it amongst themselves in private is a very remarkable thing. I think it enhances democracy. It shows public participation. Most people, what they know about the law is what they see on TV. When they get in the room, when they see a trial unfold, when they participate, they have a better respect for the law and the processes. And it's part of the transparency of the judiciary that is needed for public confidence.
Add something to that. Yes, thank you for the question. The jury system is a tremendous system for the reasons my colleagues have already stated, but the jury system also has an unfortunate history. It's been a history of bias by jurors, been used against, especially in the criminal context, defendants. And so I only raise that not to say it is not a good system, but it is a system that's a work in progress. It's a system that constantly needs to be reevaluated and improved. And one way that it gets improved is by the judge playing a role to ensure that people who may be biased do not sit on that jury, and that lawyers, advocates, do their job to question prospective jurors, to try and surface these biases. Some biases are expressed. A juror may say outright, I think anybody who is prosecuted must be guilty. I believe anything a cop says is true. Right? They may have just these biases that are very expressed. Others are what we call implicit biases. Biases that they may not be aware of. No juror will ever admit to a question that, yes, I am biased. That's not the way you identify a potential problem with a juror. You have to ask a range of other questions to get to the core of what might be some little thing in the back of their mind, some idea, some experience they've had that renders them unable to serve, or that you need to cure through some questioning for them to identify for themselves. That may be a problem. I have to check my bias at the door. So it's a great system, but it's one that requires we're ever vigilant about who gets on these juries, and one big problem we have is trying to get a better range of experience on our juries by having people from all different communities sit on the jury. It's not much, our saying is a jury of your peers. But again, this is the troubling history of juries. For a long time, of course, women could not serve on juries. People of color could not serve on juries, or were otherwise excluded from juries, even if not by law, but by the fact, by the practice. And when you exclude groups from a community, it's no longer representative. you don't feel like justice is being done in a courtroom when everyone looks like someone else. Everyone seems to not know anything about your life, your experience, the community you come from. So jury, the idea of the jury is a wonderful, wonderful democratic overlay on our system, but it's one that we have to continue to revisit and ensure that is applied fairly across all communities. But thank you for the question.
The jury system arose in England, actually. If you see history of law by Lee, he discusses it. After the decision of the apex court in the Prem Ahuja murder case, popularly known as Prem Ahuja murder case, that is K.M. Nanavati versus State of Maharashtra. The jury system that was prevalent in our country was given. The basic idea of jury system as it obtained on Indian soil is bit different from as it obtains on foreign soil. This is number one. Number two, the scholars on this subject, they say the jury system gives more social acceptability to the verdict. But it is not that simple. Therefore, we gave up that jury system. It is not that jury system is bad or jury system is good. It all depends upon the people, their history, their belief system. There are a host of factors to enter. That's how Dr. K.M. Nanavati will give up that jury system.
Even in countries where there is loose jury system, certain exceptions are made where the judge can dispense with the jury to decide the case itself. See, it all depends upon the policy of law.
At the beginning of this visit, we were planning this visit, we created something called the India-US Law and Justice Forum. And during this conversation, I want to say that we intend to continue this conversation. I personally want to make it as an annual feature when we bring 10 to 20 distinguished judges and jurors from US. And I want to make a commitment that we will come to the Karnataka High Court every year and we will have such a program with the BENGALURU Bar Association as there has been the most intellectually stimulating and engaging exercise. Thank you very much.
Beautiful subject. Thank you, sir.